Good afternoon. Welcome to the Hudson Institute's event on Google versus Oracle, decoding the oral argument in the Supreme Court. I am delighted to be joined today by two extremely knowledgeable and well-versed in copyright policy and IP policy, more generally, panelists to be talking about the oral argument from this past October 7th that occurred in the US Supreme Court in a long-running blockbuster case, Google versus Oracle. My name is Adam Mossoff. I'm chair of the Forum for Intellectual Property at the Hudson Institute. I'm a senior fellow. I'm also a professor of law at the Anderson Scalia Law School at George Mason University. Joining me today are Steve Tepp, president and CEO of Sentinel Worldwide and a professorial lecturer in law at George Washington University Law School, and Tim Wilson, director of patents at the SAS Institute. So welcome. And today, we're going to, as I mentioned, be talking about the Google versus Oracle case. As I said, this is a blockbuster case, and it really is. It's a long-running case. It's been running now for approximately a decade. It arose from a breakdown in negotiations in which Google had been attempting to obtain a license for a very long time, originally from Sun Microsystems, which had developed the Java computer program, and eventually it was purchased by Oracle. And so the attempted licensing negotiations continued with Oracle to use this program in Google's, at that time, new smartphone, the Android smartphone operating system. As I mentioned, negotiations did not pan out, and so Google decided to simply take the code, use it, and put it into its Android operating system for its smartphones without permission from Oracle. Ultimately, and this is undisputed in the case, it copied 11,500 lines of computer code. Oracle eventually sued actually for both patent infringement and copyright infringement. The patent infringement claims eventually dropped away, and what remained was a copyright case. And the case is proceeded on two grounds. One is whether Oracle can actually have a copyright in the computer code that constitutes this computer software program known as Java. And what Google has been arguing on its behalf, which is that its taking of the code, even if it was protected by copyright, was fair use. This case has been running on, as I mentioned, for a decade. It traveled at least twice through the court systems before eventually landing in the US Supreme Court in recent years on these two issues. So the two issues the Supreme Court is deciding is, first, whether the type of computer code that is instantiated in a Java software program is covered by the Copyright Act, and whether, if it is, whether Google's taking and using of that code without authorization from Oracle counts as fair use under the fair use defense provided in the copyright system. And as I mentioned, it's a blockbuster case, not just because it's a battle of titans in the high-tech industry, Google and Oracle, but it's the very first time that the US Supreme Court will be ruling directly on the copyrightability of computer code and software programs. And it's the first time in approximately 2 decades that it is going to be deciding, again, the issue of fair use, the scope and nature and protections afforded by this affirmative defense in the copyright system. So as I mentioned, we have two great individuals to speak with us today. I'm not going to be giving their lengthy accolades and achievements and other professional accomplishments over their time period, because I know that we all want to hear them speaking more than just me going on about this. So please Google them and find all of that information about them. But let me just kind of kick it off by first starting with Steve. So Steve, how receptive were the justices to Google's arguments about the copyrightability of Java, about the copyright code issue itself?
So thanks, Adam. Thank you. And thanks to the Hudson Institute for having us here and putting on this program. I think it's a really important one. It's an important case, as you've already outlined. The justices were not particularly interested in Google's copyrightability arguments. In fact, the case seemed to go very well for Oracle at oral argument. A couple of the justices, interestingly, seemed to poke at Google for its shifting strategy, first emphasizing a functionality claim, arguing that in their initial brief in this case, that, oh, well, the code performs a function and so it's not copyrightable. But of course, all code performs a function. So if that's the standard, then Google's essentially asking the Supreme Court to ignore explicit congressional enactment and hold software is not copyrightable. And it's pretty clear the Supreme Court's not going to do that. So now instead, Google is making their merger doctrine argument, and they emphasize that in their reply brief and at oral argument. Merger, very quickly, is a doctrine in copyright law that says if there's only one or very, very few ways to express a particular idea, then we're not going to afford copyright protection to that because it would have the effect of locking up that idea, not just the particular expression. And copyright is about protecting particular creative expression. However, Google has a fatal problem with this argument. Microsoft in its Surface devices and Apple in its variety of mobile devices have code that's different from Oracle's code that Google copied, and they use for the same purpose. So that clearly shows there is another alternative, or there are other alternatives to achieve that same function. And the court seemed to latch onto that, asking a number of questions and even making some comments that clearly show they see through the merger argument that Google's trying to essentially put blinders on the court. Don't look at Microsoft and Apple, just look at this. And of course, let's remember, in the long history of this litigation, the Federal Circuit ruled in the first go-round that the software was copyrightable. Google appealed to the Supreme Court, a cert petition, and the court denied cert. So there's a good reason to think they've already thought through the copyrightability arguments and that they don't buy Google's position.
Is there a straight just for textualist argument rooted in the Copyright Act that this code is copyrighted?
Well, yes, exactly. As I said, back in 1980, Congress amended the statute to make it very clear that computer code is to be protected under the Copyright Act as a literary work. It's not the functional aspects that are protectable. Those are the subject of patent law, if at all. But Google copied the code, and that's what Congress was very clear it wanted to protect.
Steve, if I might, I just wonder your perspective on the argument that Google makes that, kind of this became a patent-like right. What they said was Oracle is trying to assert here a patent-type right. Where do you think that came from?
Well, it's wrong, but that came from Google's initial argument that trying to equate the code with its function. And Oracle has clearly said, if you want to write different code that achieves the same function, you're free to do so. But you're not free to copy our particular code. And Google did exactly that. They copied over 11,000 lines of code that Oracle owns the copyright to verbatim. They copied it verbatim. And that offends the Copyright Act.
Well, then that seems to raise logically then their argument in the alternative. Well, even if it is covered by the Copyright Act, it's fair use. And so what did you think about the justice's response to Google's fair use argument?
Picking up on the fair use question, Adam, and that is Google's other major set of arguments, that, well, even if it's copyrightable, what we did is fair use and it's transformative. Because you see, they say, we took the Oracle code and we moved it from one kind of computing device to another kind of computing device. And there's no precedent for arguing that verbatim copying for the same purpose in commercial competition with the copyright owner and their licensees is somehow fair use just because you moved it from one box to another box. It's an extremely weak argument, and tellingly, at the oral argument, the justices really had very few questions about the substantive fair use argument, which to me spoke volumes. What did come up was the question of the standard of review of jury findings regarding fair use. And to me, this is kind of a tempest in a teapot. Appellate courts, including the Supreme Court, review lower court decisions. That's what they do. Fair use, I think everyone agrees, can be a mixed question of fact and law. But when you look at this case and you look at the facts, even in the light most favorable to Google, there's really no legal basis to find fair use. Furthermore, and the court seemed very concerned about this next point, it was pointed out that in the district courts, fair use issues are often resolved on summary judgment. And several of the justices seemed very concerned about not disrupting that common practice. So I think the court will apply the appropriate standard of review, which obviously is a higher standard for factual questions than for legal questions. Either way, Google's claims, even at their best, as Google puts them, don't amount to fair use.
I have to agree with that, Steve. I think that what they're looking to do is to get a remand, I suppose, back to the federal circuit. And the interesting question is, what would the federal circuit do with that? Because I think if you look at what Oracle was kind of one of the grounds on appeal to the federal circuit was some evidentiary questions that there were some exclusions in the original trial around their evidence that Google's use was not fair. And so in those things, I think the district court judge decided against Oracle. And so what would we be doing here is going back to the federal circuit and then back to the district court. And I don't think that's really a likely scenario in this case.
They also seem to be arguing that as a basis of the fair use point that, well, there's a norm for copying in the high tech industry, and so this counts as fair use because everyone's doing it. What to make of that?
It's really interesting, right? Because what it does is it says, kind of go back to the Napster days. If you remember, Napster was kind of a file share, the first music file sharing system that was a complete copyright infringement. I mean, everybody's music could be shared. You'd rip your CDs, you'd upload them to the internet, and then anyone could download them and listen to it. Everybody knew that was completely illegal, right? But everybody did it anyway. And I think that's kind of the argument that Google's making here, right? Is that, it's common practice for everybody to steal everybody's software in the computer industry, although that's not necessarily true, right? There are certain big exceptions to that, like, for example, Oracle, right, which is a proprietary software company, and Adobe, right, which is a proprietary software company, and Microsoft, which is a proprietary software company, that don't allow that kind of copying, wholesale of their software. And so, again, I think that's a relatively fanciful argument, and it's repeated, even though we have these, 75 law professors who all think it's perfectly fine to copy the software in this way, and it's perfectly acceptable to go ahead and, in the software industry, this is just common practice. Well, even if you're talking about open source, right, where you go ahead and share your code with folks so that they can then extend the code. Well, you don't just get that software with no license. Why do you need a license to have the code? Well, because of copyright. It's copyright. It's copyright protection. So not only is kind of Google arguing here for the destruction of the proprietary software business, right? But they're also, you know, it would be very disruptive, I think, to even the open source software business, because we, you know, what are we left with if you don't have copyright of the software code? And again, you know, just kind of going back to the original proposition that software is protectable under the Copyright Act, right? And so, you know, it doesn't say except for declaring code, right? It doesn't say except for, and here's another one, except for, you know, computer software programming languages. Those clearly aren't copyrightable. Well, what are you talking about? Of course they're copyrightable, right? You sign up to a license when you download one of those, you know, C systems, right? The issue really is about standards. It's not about whether the software is copyrightable. And if we can agree, like we have a very well understood method of, you know, operating in the patent space with standards. And I think we have a equally understood, you know, way to operate with standards in the copyright context. And, you know, it is certainly not that people can just kind of wholesale copy your code and without license go merrily down the road.
Well, I guess I have to say, as the law professor, I was not one of the people that joined that brief. I joined another law professor amicus brief that tried to be more sensitive to the realities of what happens in the innovation industries and the creative industries. But speaking of amicus briefs, so Steve, you filed an amicus brief in the case on behalf of copyright scholars and thought leaders who have extensive experience in both government and in the private sector. What did you and your fellow amici argue in your brief and contributed to the case?
Thanks, Adam. So I was proud to write a brief on behalf of an array of former government officials, including senior congressional staff, folks from the Copyright Office, former FCC Commissioner and Hudson Institute All-Star Harold Furchtgott-Roth, as well as practitioners and copyright professors. We made a number of arguments about the weaknesses of Google's copyrightability claims. I've already discussed those, so I won't repeat them. We also made a few points that I think few, if any, other participants in the case did, so I'll focus on those. On fair use, returning to that for a moment, we made the point that Google's copying was verbatim for commercial purposes and for use in exactly the same way that Oracle and its licensees use that code. So of course, there's nothing transformative about that. We went on to point out that a fair use ruling, if the Supreme Court were to adopt Google's rationale, would expand that doctrine so far that it would violate international standards. The global standards for copyright exceptions is known as the three-step test. That exception must be for certain special cases which do not conflict with normal exploitation of the work and do not unreasonably prejudice legitimate interests of the right holder. The United States has signed on to 16 different treaties and agreements that bind it to this standard. And it's pretty clear that if such a blatant commercial competition through unlicensed copying were permitted under the US Copyright Act, if our act is that weak, then it almost certainly violates both the second and third prongs of the three-step test. And it's not a balancing test. If you violate any of the three steps, you violated the test. So in addition to our obligation to meet our own commitments, and it's worth mentioning that a dozen of these instruments are US free trade agreements, including the Trump administration's renegotiation of NAFTA, known as the USMCA, that include this. So we've been telling other countries, you have to live by this. and were the court to rule for Google, all of a sudden we wouldn't be living by it. And that's not only an embarrassment to us, but what happens, for example, when we go to other countries, when we send our trade negotiators, of which I was once one when I worked at the Copyright Office, to go to other countries and say, you need to do better. And as many people know, there are many countries around the world where copyright protection and enforcement is not what it should be, including very notably China. And I can tell you from firsthand experience, having negotiated directly with the Chinese government, having litigated against the Chinese government in front of the World Trade Organization, they watch very closely what we do here at home. And were the court to rule that this is fair use, it would not take them more than 10 seconds to throw that in the face of our trade negotiators as an excuse for them to do less or not do more, which they really should be.
And Tim, your company also filed an amicus brief in the case. This is a collection of amici here in our event today. Could you explain why SAS Institute believed it was necessary to weigh in on the case?
Yeah, I think why SAS finds this a very important case. I mean, obviously, we're a proprietary software company. We protect our software, vociferously, and to have a situation where copyright and copyrightability can be in question in this way, would be would really be a difficult situation for a company that relies on software copyrights for its business. And I think that's it's a fair point that that there are various different ways to kind of to approach the software business. And one way is in the proprietary model where you get your benefit, right, of the work that you actually put in, the creative work and the expression of all these thousands of people that might work on a article of software over 40, like let's say a 40-year period of time. You get your benefit directly from your customers, right? They pay you money because they see a value in using your software that is bigger than the amount of money that they pay you. That's kind of a proprietary model. Well, in a lot of ways, we talk about the tech industry being aligned on kind of Google's side, right? And they have different business models than a proprietary business model. Where Google makes most of its money, as I understand it, is from advertising based on their search capabilities. And so the more people that they can entice on their platform to do search, the more money that they make. Well, they're kind of a software company that has attached to it this big search advertising business, or they're an advertising business that has a big software component to it. They don't charge for their software. They give it away for free. Okay, well, in exchange, you get people that come, that come on their platform. And so, what they're really asking the court is to kind of shift that balance, right? They're saying, hey, listen, we think that the free model is better. And so, we're going to make all of these kind of very sophisticated, but, frankly, I think very weak arguments about how, the court ought to not allow for the copyrightability of this software. And so that's a little troubling. And, it's kind of one of the reasons why we wrote this brief was just kind of to point out that there are different varying business models. But the fundamental point is that you own what you do, right? You own what you create. And that's just kind of a fundamental principle of copyright. And, the right of ownership is the right to exclude others.
Mm-hmm. Beyond the legal issues that Google's also made policy arguments in the case. It's claimed that Oracle's position would require inefficiency rather than allowing others to make use of a well-known and effective tool like Java and other application program interfaces. So what's your reaction to that, Steve?
This is really, all Google's got left. The facts are very unfavorable to them. They took someone else's code and they just copied it, put it into a commercial product. Their legal arguments candidly contort the Copyright Act and the Supreme Court at oral argument. Everyone except Justice Breyer, who we knew was going to be for Google because he wrote a law review article back in the 1980s saying software shouldn't be copyrightable. So we knew where he was going to be a long time ago. Except for him, most of the justices didn't seem to have a lot of sympathy for Google's legal arguments. So what's left? Pound on the table. So Google makes this argument that so-called efficient infringement. Well, infringement's always more efficient for the infringer, but it's still infringement and is bad for everybody else. And frankly, this is another variant of an argument we've heard many, many times in the past and that has been rejected, that copyright somehow inhibits innovation. Mm-hmm. That was not the view of the founders. The Copyright and Patent Clause of the Constitution talks about promoting progress. That's why they wanted to have intellectual property laws. Throughout history, Congress has enacted copyright laws to promote progress, creativity, and innovation. And the Supreme Court has held that copyright is an engine of free speech.
Yeah, I think, I'm sorry to interrupt.
Go ahead, Tim.
I think that also you see here what Google is arguing is just kind of that the developers, I mean, the poor developers, right, that have spent all this time and effort, right, becoming competent in the Java language, should not then be locked in, right? They call it locked in to this one system, right? And not be able to program on these smartphones that we've, kind of all become accustomed to. And so we ought to, in order to, allow the developers to take advantage of the knowledge that they developed in the Java language, they ought to be able to use that or reuse that on the smartphones on this new platform. Well, developers are not tied to a particular language, right? I mean, over and over and over again in history, developers have moved from the Fortran, the COBOL, the C, all of these languages, are when a new language comes out, what do? As a developer, you learn how to use it. And guess what? A lot of your knowledge does translate from one language to the next, right? And so if all you're learning are the new words that you have to, use in place of the old style that you had in, let's say, Java, if Google came up with a new style, you could go and learn that programming language fairly easily. It's the programming patterns that you would be able to carry from one language to another language, right? A for loop, a while loop, a do loop, all of those things that you might, how do you access the memory locations? All of those things that you would really, take with you. That's the efficiency that you're going to gain, right? As having programming knowledge. Is it easier, right? The question, is it easier? Well, yes, if you permit copyright infringement, if you permit stealing, of course it's easier. It was easier for Napster too. It was easier for Napster because it was free for the users, right? Everybody loves free stuff. But, interestingly enough, the way that story ends is with Apple, right? Apple comes out with this really cool iTunes, and everybody's really willing to pay. To pay a little bit for the songs and for the convenience and for the great device that Apple, created with the iTunes store. And so, if you give people a good, solid, non-infringing way to do things, they don't want to steal, right? I think in this case, developers don't want to steal things, and they don't want to profit off of stolen technology. I don't think that's too much to ask. And so I think that it's just an argument that really fails when you think about how the computer software industry develops. I think the last thing that you look at is, evidence that this works is there's a good, thriving, still software business in the United States. And it's still developing, new programming systems. And copyright is still doing the things in software that it was intended to do by Congress. And if Congress wants to make another determination, it very well knows how to do it.
So, Tim, you made a few great points there. I found it interesting in the oral argument when Justice Breyer asked the government, because of course the US government has come in support of Oracle on this case. They asked the government, Justice Breyer asked the government, how could you come to this position? And he seemed almost offended by it. And the Justice Department said, well, remember that the developers who are favoring Google have a business interest, a commercial interest in doing so. And I thought that was very telling. Google's arguments here try to create a false dichotomy between the notion of open use and copyright. But this ignores the reality that the copyright system is designed to promote licensing, which allows the copyright owner and other users and all of society to benefit. And in this particular case, Oracle even offers the code on an open source basis with no requirement for payment. So the facts don't match with Google's arguments. But even if one accepts the Google's paradigm that the Oracle declaring code is an industry standard that others should be able to use, there's already a universally accepted approach, which we discussed also in the brief that I filed. And Tim, you alluded to this earlier as well. In patent law, there's a well-established approach for dealing with protected industry standards, known as standard essential patents. And that's known as the FRAND doctrine, that they should be made available on licensing terms that are fair, reasonable, and non-discriminatory. That's exactly what Oracle does. And the FRAND approach is accepted across different government authorities that deal with technology, competition, patent law, and across different industry sectors in the private sector. And it's always recognized as pro-competition, pro-innovation, and consumer-friendly. So here, Google's not only trying to argue that Oracle's declaring code is an industry standard that they should be able to use without any notion of authorization from the right holder. They're then saying, and don't apply the same approach that everyone agrees is the right approach in the context of standards in the patent system, which requires licensing. Here, I should be able to copy it and use it commercially without a license. That's an extreme position, and I don't think the court will or should adopt it.
Yeah, in fact, it's interesting because perhaps Justice Gorsuch was impressed by your argument, because I recall him asking a question of Google's counsel during the oral argument about, well, you seem to be saying that essentially that this is like, I have a competitor who has such an essential facility that I just should be able to access that facility for free. And he said, that's what sounds like your argument to be. And this essentially, maybe he picked up on your points about standard essentiality and the ways in which both the private sector as well as the law have provided mechanisms to address these issues and to facilitate licensing and to facilitate cooperation and commercialization of new products and services. It's interesting that Tim has mentioned Napster. because I think in the background, one often thinks of is the creative industries. One often thinks of copyright, one thinks of the creative industries, not the high-tech industry. So it's a little unusual that we have this big blockbuster copyright case involving two high-tech companies. But does this case, Steve, have any implications outside of the high-tech sector for the creative industries that rely on copyright to secure their works, such as music?
For sure, across the board, and that's why you saw Amicus participation by a wide range of creative industries. You know, on the copyrightability side, if Google's arguments were to prevail, particularly on how they try and combine and conflate the notion of expression and function, that would throw all of copyright into a metaphysical morass. I mean, what is sheet music but a set of instructions for playing notes? So
interesting there, Steve. I think, one argument is, I mean, software by its very nature is somewhat functional.
Of course.
Right? It's also expressive. So it's both. And so Congress knew that when they said software is copyrightable. It's not like this is not some new kind of newfangled argument. I mean, this was the foundation of software by its very nature is both functional and creative. I know there were arguments back in the day, should we create a special right that's not patents, that's not copyrights, a special right for software, and that was rejected. They said, right, we have enough. We have copyright, we have patents. We don't need to create a special right for software. It's not that different. And I always kind of go back to this arguing by analogy that we try to do. We try to talk about how many, we heard how menus were set up in a restaurant and how, grocery store shelves were set up, and the QWERTY keyboard. I mean, come on. That was a mechanical device. It was done to it was created that way to slow down the typists so they couldn't, so that the keys, the actual mechanical keys wouldn't get stuck. That's where QWERTY came from. It's certainly, functional. So, software just doesn't fit into that bucket, right? You don't have to analogize to it. Software is copyrightable, full stop. We should try to focus on the fact that this is software.
So, Tim, again, you make great points, and in fact, these are not new questions. What Google's trying to present as some difficult new close call was discussed at length in the Conference on Technological Uses report that Congress relied on heavily when it enacted the software amendments in 1980 to provide copyright protection to the code. And that report is very clear that the code is copyrightable and cannot be copied without authorization, and distinguishes that from the underlying functions, which it acknowledges all software and has some sort of function, that's its purpose, but that those functions are distinct and do not disqualify the code from protection. Let me also mention, in answer to Adam's question about the ramifications for broader copyright industries, on the fair use side, if this sort of direct competition, verbatim copying for commercial purposes and direct competition with the right holder is fair use, if the Supreme Court says that's fair use, then every copyright sector has to wonder if fair use ever has an endpoint. It would suddenly be open season for unauthorized adaptations of books into movies, sequels of movies, blatant copying of any copyrighted work. But you know what? I'm not particularly concerned because I think the court sees this. As I mentioned, there was tellingly little discussion on the merits of the fair use claims in the oral argument. So, I'd be very, very surprised if the Supreme Court went so far as to say that that this was fair use.
Yeah, I mean, the elephant in the fair use room is as both of you have mentioned, is the direct commercial purpose in the copying that they took the code for the purpose of selling a product in competition with not only Oracle but with Apple and other companies. And it would, I agree, it would be surprising if that
And unsurprisingly, right? Also, the Chromebook part of this, right? So even if they say, well, we just used it in this new transformative area, which was the smartphone. Well, guess what happened right after the trial? The Chromebook was announced. And of course, they used the same, Chrome operating system for that. So it's a very, very, very similar, if not the same use. So it's just a terrible, I think, argument at that point.
Yeah, Google tries to get around the commercial aspect of this by arguing it's transformative.
Yes.
And how is it transformative? They say, well, we used it for the first time in a smartphone. And smartphones are smaller, they have smaller interfaces, they have less processing speed, they have limited electric power with batteries. Now, it's disputed whether or not they were actually the first to use Oracle's code in a mobile phone or a smartphone. But again, even if we take the facts in the light most favorable to Google, all those sorts of considerations, the power capacity, the processing capacity, those are functional considerations. And changes that are made, expressive changes that are made solely on the basis of functional considerations, are anathema to creativity. That's bedrock copyright law. So for Google to say that their best argument, apparently, is that it's transformative because of all these functional considerations, they haven't made a very strong case.
Well, this has been a fascinating discussion. And before we close out, I think we, of course, have to ask the question that goes with any event that covers an oral argument. What will be the outcome, do you think, of this case? Now, of course, predictions on how the Supreme Court decides a case are always fraught with innumerable and unknown variables. It's a bit like reading the tea leaves. But let's just say, with all of the appropriate caveats, how do you think this will come out? Tim, I'll start with you, and then we'll go to Steve.
Thanks, Adam. I really don't think there's much question in this case from the oral argument that Oracle is going to prevail here. Is there a possibility that they might remand? It's a slight possibility, but I do believe that Oracle is going to prevail.
You mean remand on the standard review and the procedural?
Yeah, exactly. On fair use, yes.
And Steve?
So Tim mentioned Napster, and I think that was an apt comparison. I'm also going to mention Grokster and Aereo, both Supreme Court copyright cases. In both of those cases, defendants tried to build a commercial enterprise through unlicensed use of others' popular copyrighted works, which sounds a lot like what Google did here.
Yeah.
Like Google in this case, both Grokster and Aereo tried legal arguments that contort the meaning and intent of the Copyright Act. And again, it was telling that at oral argument, the justices didn't seem very impressed with Google's arguments. Like Google in this case, Grokster and Aereo tried to paint the Copyright Act as an obstacle to innovation. But as we've already discussed, that's not how the framers and the Constitution and the Congress and past Supreme Courts have viewed the copyright law. Another similarity is that the amici in Grokster and Aereo presented the courts with a parade of horribles if defendants should lose. Today we have very similar sorts of things, including some of the very same amici who made those claims. But as we know, Grokster lost and Aereo lost. The Supreme Court repeatedly recognized that copyright promotes creativity and innovation. The court was not misled by attempts to twist the Copyright Act. And the predictions of those amici they were wrong. Their predictions simply didn't come to pass. So when we get into the particulars of this case, as we've just done, we see the weaknesses of Google's specific arguments. And at this sort of 50,000 foot level, we see that the Supreme Court has a history of seeing through all this and ruling in favor of the Copyright Act against blatant commercial infringement. So given those histories and what I heard at the oral arguments, I'm hopeful for a good ruling in this case.
All right. Well, thank you. And I hope that you will both be available and willing perhaps to come back when the decision comes down, where we can hold your feet to the fire on these predictions and we can assess actually what happened in the case. We will certainly all know for guaranteed purposes, at least by June 30th of 2021. So
I do like being in violent agreement. That was quite good.
Well, thank you again, Steve, and thank you again, Tim, for a fantastic discussion of a really important issue. Thank you, everyone, for joining us today, and I hope that everyone has an excellent week.
Thank you.
Thank you.